Harrison? Whenever you're ready, sir.
Thank you, Your Honor. Good morning. May it please the court, Richard Harrison for KMG, the plaintiff below. I'd like to reserve 5 minutes for rebuttal, please.
All right.
This is a case about everyone's favorite topic, service of process.
You know, you
particular-
write so much about service to process.
In particular, service of process under our newly revised and recodified statute. The underlying case is not complicated. Al is a general contractor, my client owned property, they did work, there was a dispute. Al filed a claim of lien, we filed an action under 713.21 to discharge the lien. That's a special statutory proceeding designed to expeditiously resolve lien claims. Al did not respond, the clerk entered a default, the court ultimately entered a final judgment vacating the lien. A couple of months ago,
Let me ask you something. If we were to accept that the return is regular on its face, convince me that there was convincing evidence to rebut that presumption.
oh, I don't think there was. The trial court said there was, but as we get into this, I think they're trying to be a little too clever by half. They're sort of not contesting things, but they are, and we're going to get to that. But the return was regular on its face. In any event, a couple months go by after the judgment, they turn up, motion is set aside, and their claim is service was invalid, therefore no jurisdiction, therefore the judgment is void. Trial court had a hearing, the process server testified, the registered agent testified, and the trial court ultimately agreed with them, said service was no good here, judgment's void, set it aside. We're asking this court to reverse, reinstate the final judgment, and that case will be over at that point. The trial court, in our view, misapplied section 48.062 and section 48.091.4, and I'm going to walk through it shortly. And then while they were misapplying those, they completely ignored 48.091.3. So I'm going to walk through that, but I do want to talk about the service of process. That's what we're here about. This is a limited liability company, so they have a statutory registered agent. Under chapter 48.091.3, corporation registered agent has to do 2 things. They have to keep the office open 10 a.m. to noon on weekdays, and the statute says keep 1 or more individuals who are or are representatives of the designated registered agent on whom process may be served at the office during those hours. Individuals or representatives. Doesn't say employees. We're going to come back to that in a minute. Service of process happens here during the statutory hours. Process server shows up, he goes into the registered office. It's a little business run out of a converted home. Sees a woman in the reception area. Her name turns out to be Miss Feebles. I don't want to keep calling her that lady. He identifies himself as a process server, says, I need to serve the registered agent. Miss Feebles says, I can take it. He says, no, I really need to serve the registered agent. Miss Feebles says, well, she's here, but she's busy. Process server says, well, you better go back and check with her and make sure you can take this. She toodles off. She comes back a minute later, says, I talked to the registered agent, I can take the papers. At that point, he gives her the papers. All of this is laid out in the return of service in great detail. Now, there's no dispute about that version of events, because they say in their brief on page 23 that they're not challenging that Ms. Feebles made this statement to the process server, just as he said it occurred, since it explains the behavior of the process server. So they're not challenging that Ms. Feebles, interacting with the process server, did exactly what the process server said, yet they contest the registered agent says, I never authorized her to accept. That's what they're contesting. So we have to bounce through the statute, and I think the problem will become apparent.
What's the process server supposed to do when Ms. Feebles says, I can take it? He's basically refused access to the registered agent. I mean, I'm trying to figure out what if anything more you can do other than just leave it to somebody who said, I can take it?
Well, I don't know what else the process server could do, and I have to tell you, what we just described probably happens hundreds of times a day all across the state of Florida with process servers serving process. If the lawyer happens to be a registered agent for his many clients, process server walks in, the lawyer's not going to come marching out of his office to accept service. He's going to say, leave it with the receptionist, leave it at the front desk. This goes on every single day. The process server can't really interrogate that lady. He can't barge back to where the registered agent is. He can't do any of those things. He's an officer of the court as a process server, and I think he's authorized and entitled to rely on what is communicated to him by somebody in the registered office at that moment.
But he's relying on what Ms. Feebles said.
Yes.
So she's basically saying, I'm the agent of the registered agent.
No, something more than that, though. She says, I went back and talked to the
Okay.
registered agent, and she said it's okay.
And at that point, any reasonable process server would accept that
Right.
and leave it with it.
Absolutely. Any reasonable process server is going to say, that's good enough, here you go, and do what this process server did, note all those details in the return, and it's spelled out very clearly. Here's where the trial court kind of went wrong. We start with 48.062.2, which is a basic rule, limited liability company, you have to serve the registered agent. Okay, we all get that. Then subsections 3, 4, and 5 of 062 cover certain problem areas that typically come up, and it tells us how to deal with them. One of which is, what if the company never designates a registered agent? What do? That doesn't apply here. Another one, part of the reason for the amendment to the statute, is to deal with some of the modern problems. One of the problem areas they cover is, well, what if the registered address is, a mailbox in the UPS store? How do you serve those people? Statute covers that. None of those subsections pertain to our set of facts, so we don't have to worry about them. There's one more problem area that's covered in 48, and it's back under 48.091, sub 4. And it tells us what happens if the registered agent is temporarily absent from the premises. And it says, if the registered agent is temporarily absent from the premises and it's your first attempt, you can serve an employee of the registered agent. That is the only place in Chapter 48 that says it has to be an employee. Somehow the court latched onto that. That was their argument below, number one. She wasn't an employee. The court latched onto it, made a finding she was not an employee. But that section can't possibly apply here because everybody, including the registered agent, said she was there. The registered agent testified, I was there. Ms. Feebles said, she's here, she's just busy. So we can't apply a subsection that turns on the agent being absent from the premises when everybody agrees that she was there. If that doesn't apply, we never get to any requirement of having to serve an employee of the registered agent because that's the only place it appears. So the trial court misapplied the statute, applied the wrong section. It totally ignored, by the way, the section I just talked about, 091 sub 4. We cited that throughout our papers below. I don't think they ever commented on it. They never argued it. The judge never really said anything about it, but made this finding that service is no good because the lady you served, Ms. Feebles, was not an employee. Again, that's the only place that comes from. So that had to be what the judge was turning on below. All of Chapter 48, as you know, was amended, it was substantially overhauled. It's one statute that deals with service of process. The court has to construe the different pieces of it together. Can't pick and choose, can't take one and rely on it to the exclusion of everything else. It's a cohesive scheme. The whole point of the revision was to solve some problems and give us a cohesive statute on service of process. And here the trial court just got it wrong. That's a matter that this court reviews de novo. The finding that the judgment was void, which flows from the trial court's statutory application is also reviewed de novo. And we think the trial court just got it wrong here. So that judgment, setting aside the order setting aside the judgment should be reversed, and the final judgment below should be reinstated.
Thank you.
Thank you. May it please the court. My name is Attorney Richard Boyle on behalf of the appellee, Owl Construction. And before I get started, I'd like to address a question posed by Your Honor LaRose to Mr. Harrison, which was why this return was not regular on its face. This return was not regular on its face is because Unia Feebles is not affiliated with Owl Construction at all. One of the biggest issues in this case is the problems of the factual representation of what occurred in this hearing in August. This question before you today, this entire appeal, is a mixed question of law and fact. So I'd like to go over some of the facts that were testified to during the hearing in August. One of the facts that was testified, yes, sir.
If there, on the face of the return,
Yes,
the process server does give some detail as to what happened.
correct.
Yeah, so there seems to be no question. Ms. Peoples was there. There's no question that the registered agent is there. She's not available. Ms. Peoples comes out and says, I can take it, and he details that, right?
He does. He details that in the return. He does not use the term substitute service on the return, so he doesn't outline the manner of service. But I understand and accept Mr. Harrison's argument is that the label of substitute service is not necessarily the substance of what substitute service is. I understand that. However, Ms. Feebles is not affiliated with Owl Construction. And what he represents in his return is that Ms. Feebles was authorized to accept and that she was an administrative assistant. Yet during his testimony, he says he can't remember if he asked her if she was the administrative assistant of Owl Construction or Accounting and Beyond LLC, which shares a location with Owl Construction at 7121 North Havana Avenue.
Behind what's on the face of the return?
So I don't think it does. I think that on the face of the return, it does need to have the word substituted service, okay? And I believe that the trial court also agreed with that. However, beyond that, the trial court also found that we, as the moving party in that case, presented clear and convincing evidence that service of process was not properly effectuated under statute 48062. And that would essentially render their other finding, which was if a return was regular or not regular on its face, almost moot.
To accept that, do we have to say that Ms. Feebles was lying?
So I don't think we have to accept that Ms. Feebles was lying in that she had any malicious intent. However, I think we do have to accept that she was not providing the full information as asked by the process server. The process server, and this is where the words are super important, okay? The process server testified that he walked into the building and he indicated that I'm here with an official document for the company. That's all he said, the company. He didn't say Owl Construction. He testified that he was there for the company. When I asked him on direct, was he aware that that Accounting and Beyond LLC also held its principal place of business at 7121 North Havana Avenue? His answer was no, I was not aware. So he goes there and he talks and asks the first person he sees, I'm here about the company. And I have an official document from Ms. Rojas Quinones. And to give you guys a visual, the same way we presented to the trial court, this is a converted home that is now a commercial building. This converted home has about 8 feet between the registered agent's office and the front door. That's 8 total feet, so closer than you and I are right now. And he walks in this door, there's an alarm that goes off that says front door open as soon as he opens the door. Okay, and as soon as he does that, Ms. Feebles is there at the front desk, greets him. He identifies himself as a service processor and says, I have an official document from Ms. Rojas Quinones of the company, and I need to speak with her.
But we know she is the registered agent.
She is the registered agent, yes.
And do we know that Ms. Feebles knew she was the registered agent?
I don't know if she knew that she was the registered agent of Owl Construction. I would assume that she did because Ms. Rojas Quinchones is not just the registered agent, she's also the principal. So it would be assumed that she knew, okay? Ms. Feebles was the 1099 contractor, administrative assistant for accounting and beyond. And this is where the ruling inside of the trial courts, their mention rather of their order about her being an employee of Owl Construction or not is relevant, is that she wasn't even affiliated with Owl Construction. She was affiliated with accounting and beyond. She was a 1099 contractor for accounting and beyond. And as Ms. Rojas Quinones testified, she handled bookkeeping and other administrative tasks for accounting and beyond. Ms. Rojas Quinones testified that she wasn't even authorized to open up the mail, never mind accept service of process. The problem with Mr. Harrison's argument and with the argument presented today is that accepting that anyone who is present inside of a registered agent's office during the hours of 10 and 2 and tells the service processor, sure, I can take it, allows anyone, whether ill-intentioned or mal-intentioned, to essentially rob the registered agent of service processor.
An additional step. I mean, it's not like she's sitting at the desk, here's, fine, I'll take it. You know, she apparently takes a step of going into the office and making an inquiry of Ms. Rojas.
Actually, that's the part that we questioned Mr. Woods on. And like one of the main questions is, did you hear Ms. Rojas Quinones on that day? And his answer was no. Did you see Ms. Feebles go into Ms. Rojas Quinones' office? No. I saw her leave the room and go elsewhere. So we don't know. She could have went to the bathroom. We don't know where Ms. Feebles actually went. And Mr. Woods didn't hear Ms. Rojas Quinones, didn't see Ms. Rojas Quinones. It's not like Ms. Feebles called her on the phone and said, hey, I have this service processor here. Let me put you on speaker. What would you like me to do? That did not occur. And Mr. Woods testified to that. He also arrived just before 10 a.m. And the reason we know he arrived just before 10 a.m. because he wrote in the return that he handed the papers to Ms. Feebles at 10 a.m. Not 10:10, not 10:20, but 10 a.m. So we're talking about between the hours of 10 and 12, which is the statute that Mr. Harrison is referring to, where it requires a registered agent to keep someone in their office, in their principal place of business, between the hours of 10 and 12 to receive service of process. Well, Ms. Rojas Quinones testified that she was actually working on the 28th, but she didn't see Mr. Woods on that day. In fact, what bolstered her testimony was 3 days later, after Mr. Woods initially came in this matter, he actually returned at the request of the appellant on a related case and personally served Ms. Rojas Quinones in almost the exact same manner. Only this time she was there and he personally served her. And this time it was, I believe, at 12:48 p.m. And that was also presented to the trial court. So this is a mixed question of law and fact. This is not just only a question of law that your honors would review completely de novo. There were findings of fact that the trial court made, and they made it based on the testimony presented by Mr. Woods, and then also the uncontradicted testimony of Ms. Rojas Quinones. One of the biggest arguments that
Can I ask you a
Absolutely.
side question? Is it right to tell us whatever happened to Ms. Feebles?
So the record says, according to Ms. Rojas, that she is no longer affiliated in the middle of May. She actually left accounting and beyond. The record describes what Ms. Feebles' role was within accounting and beyond, and that's it. And Ms. Feebles did not testify at the trial. Only Ms. Rojas Quinones testified, as well as the service processor. They testified. Ms. Rojas Quinones' testimony was subject to cross-examination. And on that cross-examination, she was not asked about accounting and beyond at all. She was not asked or challenged about the fact that accounting and beyond holds its principal place of business at the same location. And the best analogy I can present here is in an age of virtual offices where you have one office building shared by multiple people. If a service processor walks up to a shared receptionist and says, hey, I have an official document for the Boyle Law Firm, for Mr. Boyle, please make sure he's here. And they say, well, I can take it. Would that then be acceptable and not be substituted service? The law talks about if a registered agent is a natural person, Well, then if she's a natural person, which Ms. Rojas Quinones is clearly a natural human being, then the regular process of service should apply to her. In other words, they could go to her regular place of abode and they could leave it with an adult over the age of 18. They didn't do that. Okay, she testified that she doesn't live at 7121 North Havana Avenue. She lives at 4932 Pensbury Drive. She testified, they also could have gone to another principal of the LLC. They could have gone to Mr. Juan Quinones, that she testified was the other principal of Owl Construction LLC. They didn't do that. They also could have come back to a second attempt at the location to try to find her, perhaps maybe another 20 minutes after exactly 10 a.m., and they likely would have encountered Ms. Rojas Quinones, but they didn't do that. In this case, they even went back 3 days later and served personally Ms. Rojas Quinones with a related complaint, and they had an opportunity at that time to cure their defective return. And the reason I keep coming back and saying that the return itself was defective is because it straight up says that it was served on Union Feebles, who is, and I quote, authorized to accept. That statement of authorized to accept, as Mr. Woods testified, he only took the word of Ms. Feebles. He did not verify that from Ms. Rojas Quinones. And that is a problem, because this allows essentially any client, any potential either do-gooder or malfeasant who might be present in the registered agent's office to a service processor to say, oh, I can take the papers, and then take the papers, and then they leave. Oh, I'm authorized to accept, and then they go. That's a serious problem. That's not what the statutes say. The statutes are very clear about the steps on when they need to serve a limited liability company. One of the findings in the lower trial court's order, was that the Owl Construction LLC is a limited liability company. And that really narrows the statute to 48062. That's the statute that applies. That's the statute that was not followed. That's the main issue. What Mr. Harrison and what the appellant is trying to do here is to conflate that specific statute with all of the other statutes. They're all relevant. They're required to be looked at as a whole. However, the controlling statute is 48062. That's what the trial court looked at, and that's what they applied the facts of this case to. After hearing the testimony of Ms. Rojas Quinones that her office is less than 8 feet away from the front door, that the door alarms as soon as you walk in, it says front door open, okay, and that she did not authorize anyone to accept service on her behalf, and that she has had that policy as not authorizing anyone to accept service on her behalf since 2009, when Accounting and Beyond LLC first started. And that's the policy he has consistently held in place since that date. And this is just a continuation of it. Ms. Rojas Quinones even testified that she had been sued only one time previously in her position as Owl Construction, and that she was personally served in that case. The record will show that second affidavit of service that was served just 3 days later by Mr. James Woods on the same time, where Ms. Rojas Quinones and Mr. Woods even had a conversation at that time where she made a comment about his name being similar to the actor. And she recalled that and actually testified to the same. So that occurred just 3 days later, where the appellant could have cured this improper service, and they didn't. And unfortunately, Ms. Rojas Quinones is not an attorney. She got this document, and this is the second document, not the first one. She got this document and she ignored it. And as the record reflects from the testimony in the trial, is that we have a default in that case as well, that we are actively moving to set aside. Because unfortunately, no action was taken until much later when I got involved in the matter. And we're trying to essentially undo it and fix some things. But in looking at it, the service of process was not followed. We have a specific statute in 48062, and unfortunately, it was not followed. Thank you so much for your time.
Thank you.
Brought too much stuff up here.
It's like a security.
I know.
Just briefly, Your Honor's couple of points. You heard counsel say the registered agent was only 8 feet away. Okay, so why is it she couldn't come out and accepted service and we wouldn't have to deal with any of this? The only purpose of a statutory registered agent is to accept service of process. That is the only function of that person on the face of the planet, to accept service of process. So this whole case arises because this lady was so busy that she couldn't walk the 8 feet when Ms. Feebles goes back to her office and says, there's a process server here with papers. And again, are they contesting what Ms. Feebles said? Because their brief says they're not, but now, Judge LaRose, you asked the question, do we assume she's lying? Is she crazy? Is she psychotic? Did she just wander to the back of the building and never talk to the registered agent, even though she came out and said she did? That seems far-fetched. The court made a specific finding that the return of service was not regular on its face because it did not include the words substitute service. And you heard Mr. Boyle talk about that. That was their argument below. Their argument below was, forget that it describes in great detail how he did this and how he put these papers in this lady's hands. That's not good enough because you didn't include the words substitute service, which would seem to be arguing that we need to favor labels over substance, which is the opposite of what we argue in virtually every case. We deal with the substance of things, not the labels that people put on them. And you can't, as much as they would like to, only look at 48.062. You can't stop there because that doesn't get you to the end of the day. You have to look at 091. The court looked at 091 because that's the only place anybody in the statute talks about having served an employee, so it had to come from 091-4. And the only requirement, doesn't matter whether her title is administrative assistant, secretary, whatever, or she has no title. Even if she's just an independent contractor for somebody else, the only requirement in 091-3 is that it's a representative of the RA on whom process may be served. When that lady walks back, comes out, tells the process server, I talked to the registered agent, it's okay, I can take the papers. That's got to be the end of the day. If that's not the end of the day, and Mr. Boyle talked about, well, he could have cured it 3 days later. Well, you don't cure something that you don't know had any problem. You serve it on Monday, you don't go back on Thursday and serve it again. This happens just like this all across the state of Florida every single day. And if what the process server did here isn't good enough, this court's going to be seeing a lot more service process cases. This is exactly what the process server was supposed to do. He did it, he documented it in the return. The registered agent's position, I did not authorize that lady to accept, is wholly uncorroborated. She testified, I didn't authorize her to accept. You raised the question, what about Ms. Feebles? Why didn't Ms. Feebles testify? Well, you would think that if she had something favorable to say, they would have brought her. They certainly knew where to find her. She didn't testify. That case after case tells us when the return of service is regular on its face, the uncorroborated denial is not sufficient to undermine service, and that's what we have here. So we think service was good, and the trial court should be reversed.
All right, thank you both.
Thank you.
And that concludes today's